Hey, everybody, and welcome to Thursday night. Welcome once again to Thursday night. John Skiba here from the Consumer Warrior YouTube channel, doing what we try to do each and every Thursday night, and that's do this live Q&A where we discuss all things debt-related, whether it's debt collection lawsuits, bankruptcy, wage garnishment, all the horrible things out there. We talk about how to deal with them and give you some tips and strategies and maybe some resources on how you can deal with the debt problem and get it behind you once and for good. Again, my name is John Skiba. I am an attorney in the state of Arizona, and that's what I do. I do mostly bankruptcy work, and then I do a lot of defending of debt collection lawsuits, particularly those brought by junk debt buyers, also original creditors. We do a lot of debt settlement, different things like that. My contact information is below if you want to learn more about what I do on a daily basis and my real job and my day job. But how we do this is each Thursday night, I like to just reach out and go over questions. Again, my disclaimers are, like I said, I'm a licensed attorney in the state of Arizona. I'm not licensed anywhere else, so I can't answer anything specific. As far as legal advice, you shouldn't consider this legal advice. You should consider it being on YouTube and hearing someone talk about things. But if you need a real legal advice, you need to contact an attorney. And if you're in the state of Arizona, I do free consultations. One thing I do tell, I get a fair amount of calls from people outside the state of Arizona, and I don't mean to be, I'm not trying to be rude or standoffish. It's just the way that the licensing works with attorneys. I can't do consultations where it's one-on-one giving advice if you're not in the state of Arizona. So I apologize about that, but I can direct you to some other resources, and you can check out some of the other videos here on YouTube if you're not in the state of Arizona. All right. So, and the final thing is it doesn't create any type of attorney-client relationship. I do get that sometimes where people want to email and kind of go back and forth, and attorneys are highly regulated, and we really can't do that either. So one of the things that like I said, I like to do is each week is go through the comment section, and the channel has continued to grow. We're almost at 30,000 subscribers, and I get a lot of comments. In the early days, I used to be able to go through the comments and respond to them and give some resources, but it's tough to do that and keep doing what I do at my work every day. So I pulled a few comments, some questions that I thought might have some universal appeal to them. So I wanted to show you those. This first one is from Tina. She says, "What if we own absolutely nothing and can't work?" And so what Tina is asking there is related to really what we call in the law being judgment proof. She's saying, look, if we've got creditors after us, if we've got people suing us, if we're looking at maybe a bankruptcy option, what if we just don't have any assets and we're not working? Maybe they're receiving like state assistance or retirement or disability or something like that. It is true that it is possible to be judgment proof where, sometimes I'll have someone come into my office and they're like that. They don't have any significant assets, or what they do have is protected by the various exemption laws in Arizona, and their income. Usually their income stream, we look to make sure that that's protected as well, like Social Security retirement or Social Security disability. Those things are exempt. They can't be garnished. So there's not a whole lot that a creditor could actually do. So in certain circumstances, I do tell people one of their options is to do nothing. They're going to have to deal with collectors, maybe calling them or sending them the snotty letters and all that kind of stuff. But it's not something where they're dealing with actually losing anything because there's really nothing they can take. There's nothing they can take from them. So it is possible to be essentially judgment proof. And where you don't have to do it, but that's something definitely I would meet with an attorney, because sometimes we think we're judgment proof and we're not. There's actually something that they could go after or cause you problems. And particularly if your situation is fluid, if it's something that could change, if, maybe like the disability, you're off work and it's temporary, it's going to be 6 months, a year, but then you're planning on going back to work. Judgments, like a civil judgment in Arizona, is good for 10 years, and it can be renewed every 10 years. So I routinely see judgments that are, were entered back in 2005 or something like that, and the creditor is still trying to go after it, still interest is turning on it, and it can cause you some problems. All right, this question I thought was a good one. This one deals with bankruptcy and rent. Dominique says, does filing Chapter 7 bankruptcy protect your apartment if you're renting? I'm so scared to file because I don't have any assets, but I do rent an apartment. I'm terrified I'll have to move out. I have a meeting with an attorney on the 25th of this month. So, Dominique, this is a good question because I get this question frequently in Arizona in my bankruptcy practice, where people are concerned if they file for bankruptcy that they're going to be in a position where they're going to lose their apartment, lose their place that they're renting. Now, and I can tell you this too, landlords get nervous about this, but in general, I can tell, I often write letters for clients telling the landlords basically to chill out, that they're going to be fine. As long as you continue to pay the rent, you're going to be fine in a Chapter 7 bankruptcy. They can't evict you. A lease agreement or a rental agreement is what we call an executory contract. If there's still we have to disclose it as an executory contract, and you have the option to either assume it, meaning you're going to keep making the payments on it and stay there, or you can reject it. So I have had situations where clients are in these really long leases, or see business contact times where there's this 5-year lease that the company's in, and the business or the individual wants to reject the lease. They can do that and then get out of it. That's why landlords do get a little bit nervous, but you can also provide them documentation saying, look, we're going to stay here. It's not going to be an issue. As long as you keep making the payments on it, you're going to be fine. So that's what as far as the rental thing, you're going to be fine there. Another follow-up question a lot of people have is, am I ever going to be able to rent? I can tell you, so a lot of landlords do check your credit, but I don't see it a bankruptcy, particularly if the bankruptcy's already been filed and it's been discharged. I don't see that be a big reason why they're not going to rent to you. For one, it shows that everything's kind of dealt with. And two, you can't file bankruptcy again for another 8 years. So, if you have a 12-month lease with someone post bankruptcy, you're going to be fine there. So, all right. Let's see if there is any questions. Let's go with Alex, our main regular here on the channel, asking, what are some objections to stop a trustee sale? So that's a good question. We're starting to see, the trustee sale is the way that homes are foreclosed on in the state of Arizona. And I can tell you that we're starting to see a little bit of like 2008, 2009 during the housing crisis. I mean, nothing to that extent, but I was just, with bankruptcy, we're always looking at valuation of homes for clients. We go to Zillow, Redfin, and we try to get an idea, just ballpark, what's the property worth. We're seeing homes depreciate 10 to 20% per month right now, which is crazy because we had such a huge spike here in Arizona not long ago. And now we're starting to see the property values go back down from where they were. So if you're in a situation where you're facing a foreclosure sale, the way that they do that in Arizona is they do it through what's called a trustee sale. Most Eastern states do it through a judicial foreclosure where it's actually a court process. In Arizona, foreclosing on the home is not a judicial process typically. What they do is once you fall behind 3 to 4 payments on your house, they then will notice up what's called a trustee sale. And they have to send you notice and they have to tape it to your door. And the soonest they can foreclose or do the trustee sale on your home is 90 days from the day that they post that to your door. So they post that to the door and they say, hey, we're going to sell your home on the courthouse steps in 90 days. It was kind of interesting. They actually do it on the courthouse steps. So when I was a young lawyer, I thought that was something maybe out of a movie, at least in Maricopa County, down in Phoenix, down at the great big courthouse, the great big steps. They have these things set up and they auction these things off, and investors go in there and try to buy homes on the cheap. So the best way to stop the trustee sale, some of the things you can do without bankruptcy is reaching out to the lender and just seeing what options they have. You'd be surprised how many programs and how many different things there are to deal with mortgages when you're behind on them to avoid foreclosure. And they may have a program that you can get into fairly easily depending on your situation. You could also ask them for a loan modification. Those are real big in the last, 2008 debacle. The loan modification where they could maybe put some of the payments you're behind on the back end of the note, restructure the payments, maybe reduce the interest rate for a little while. That's a possibility. And if all else fails, you do have bankruptcy in your back pocket. Chapter 13 bankruptcy can be filed even the day before the trustee sale or the foreclosure sale on the home. And that'll stop the foreclosure from going forward. if you're for your bankruptcy attorney's sake, I would ask you to not wait that long, because then we're really hustling to try to get it all put together and make sure we get it squared away. So what I would recommend is if all else fails, you can look at a Chapter 13 bankruptcy. The Chapter 13 bankruptcy allows you to not only stop the sale, but then you have up to 5 years to bring it current. You're going to have to start making the payment as it comes due, but it's something that you absolutely can, it's going to give you quite a bit of time to get it done. So, all right, Al, hey, thank you. You know what? I've got a whole slew of master classes I'm about to get ready to show on the schedule. So if you're interested in joining the community, the links on the YouTube in the chat there, you can click on there and you'll see a link to it. We're going to be doing some trainings that we only do for the community members. And we're starting to get a library of things that I've done there in the past. So head on over there and take a look at that. All right. Tiffany says discovery closed 2 months ago. So we're dealing with the debt collection lawsuit here. Discovery closed 2 months ago, court date in 2 weeks. And now the plaintiff has submitted documents that I see my husband, now deceased, did make transactions. Are papers admissible after discovery closes? The case is valid. Do you have to show up for summary disposition, or can I just take the no-show default? Your first question here. So a lot of it will depend on what the state you're in, but I can tell you the disclosure rules are pretty universal. It's usually Rule 26.1 in the federal rules of civil procedure. In Arizona civil procedure, it's 26.1. And what it is, it says that the parties have to disclose what documents, what exhibits, what witnesses, what evidence they're going to use if they're going to go to trial. And if they don't timely disclose it, then it can be barred from coming into evidence. So if discovery is closed and they haven't updated their disclosures at that point, I would object to anything new coming in. And the way that you do that, you can do it actually at trial. If they try to introduce the document into evidence, you can, say, objection, Your Honor, this was never disclosed prior to then. And that's going to put them on the spot. They're going to have to discuss why it is they failed to disclose this. Most courts, if it's not disclosed timely, they will exclude it. There's no, trial by ambush. The Perry Mason movies and all these old things where there's this, the murder weapon comes out and it's, aha, we did it. That's not real. That you've got to disclose. The parties have to they're entitled to full disclosure of everything that's going to be coming out in trial, the names of the witnesses, the documents, exhibits, all of that. So Tiffany, if it were me, you could also raise an objection prior to trial. You could do it through what's called a motion in limine. Motion in limine is essentially telling the court we don't want certain evidence to come in, and you could explain to them that this document was not timely disclosed. You're just getting it now, and it should not, it prejudices you because you're not able to, discovery's closed. You can't do any follow-up discovery with them. You can't do any depositions. You can't do anything. And it changes the entire format of the case. Sometimes I always say if a debt buyer comes in and they don't have any evidence, why would you settle? But if they come in the day before trial with a whole truckload of documents that make it look like you're going to lose, if you would have had that at the beginning, then it can help you make better decisions up at the front. So it's their case. The creditor, they're the ones that have to prove this, and they need to come in timely with that. So I would definitely raise an objection. Now, to your second question, if the case is valid, do you have to show up for summary disposition, or can I just take the no-show default? So what you're asking there sounds like is you're saying, hey, if I have to show up and I think I'm going to lose, do I even need to bother, or can I just take a default? I would always show up for a couple reasons. One, you might be surprised. I know I've been surprised throughout my career in doing this, how often I've won a case just by showing up because the other side didn't. The other side gets stuck in traffic. The other side forgets about it. They miss calendar or whatever, and the court dismisses the case. So I always, not only do I show up, I make sure that I'm 15 minutes early. I'm in the courtroom. I'm ready to go. And so I would always show up because there's always the possibility that they may not show up for whatever reason. And then you could win your case by default. Two, even if the case goes to trial and even if the court enters judgment in their favor, there's going to be the issue of attorney's fees. Often the creditor's attorneys will seek to have an additional attorney's fees award added on top of it. If you don't show up, the court's going to be much more likely to grant that, because sometimes it's discretionary depending on the rules in your particular jurisdiction. If you show up and you show, hey, I'm here, I'm participating in the process, that may not be the deciding factor, but I can tell you, if you don't show up, the court's not going to think twice about just granting attorney's fees. And, all of a sudden this $5,000 credit card turns into a $9,000 judgment, that kind of thing. So I would show up. And then hate court case at 10 a.m. not coming until 3 p.m. That now the lawyer's existence. The courts here aren't that bad. I can tell you that's how the bankruptcy court often was. Is you would go there and just wait and wait. They get 20 people the exact same time, and then you just wait until it's your turn. So, yeah, unfortunately, that's I always say it's their world. It's the court's world. We just work in it, or we just so they make all the decisions. So that would be my recommendation on that. I've always said showing up is sometimes more than half the battle. Sometimes it's the entire battle when you're dealing with it. So, all right. So I think that looks like that is the extent of the questions that we have. If you do have anything else, go ahead and put them in the notes to the comments below. I do go back, like I said, we can post it and talk about it at a later time. If you have questions, or if you want to check out some of the tutorials or the Consumer Warrior community we have, go ahead and YouTube. Click on that link. I have it at the top and also underneath. And if you're in Arizona, I'm happy to meet with you, do a free consultation, and we can take it from there. Thanks for watching tonight.